So the Canadian government just got absolutely roasted by its own federal court of appeal, and honestly, I'm here for it. Picture this, it's 2022, Justin Trudeau's government looks at a protest they don't like, decides the entire country is basically on fire, and slaps the Emergencies Act on the table like it's a get-out-of-jail-free card. Fast forward to now, and not one but TWO courts have basically said, yeah, that was illegal. And leading the charge? Alberta. Premier Danielle Smith and Minister Mickey Amery just took a victory lap, and you know what? They earned it. Welcome back to Canadian Insights, where we break down the political chaos so you don't have to. Buckle up, because this story has everything: federal overreach, constitutional smackdowns, and enough drama to make a Netflix series. Let's dive in. Alright, let's rewind for a second, because if you weren't glued to the news in early 2022, you might have missed the absolute circus that was the Freedom Convoy. Trucks parked in Ottawa for weeks, honking became a national crisis apparently, and the federal government was sweating bullets trying to figure out how to make it stop. Enter the Emergencies Act, a piece of legislation so rarely used it might as well have cobwebs on it. The last time it was invoked? Never. Its predecessor, the War Measures Act, was used during actual wars and the October crisis. But Trudeau's government looked at some trucks and protesters and went, "This is fine. This is totally an emergency." They froze bank accounts, cleared the streets, and patted themselves on the back. Except here's the thing, you can't just yell emergency and expect the Constitution to take a nap. And Alberta? Alberta was not having it. Now, here's where it gets spicy. Alberta didn't just sit back and watch this unfold like it was someone else's problem. Premier Danielle Smith and her team saw what was happening and immediately threw up the red flag. They applied for intervenor status in the court case challenging the Emergencies Act, which is basically legal speak for "we're crashing this party and we've got receipts." And what were those receipts? Oh, just the tiny detail that the federal government completely ghosted Alberta when making this decision. See, the Emergencies Act isn't just some power the Prime Minister can whip out whenever things get uncomfortable. It requires consultation with the provinces. You know, those pesky levels of government that actually know what's happening on the ground. But did Ottawa call Alberta? Did they check in? Spoiler alert, nope. They just went ahead and declared a national emergency without so much as a courtesy text. Classic Ottawa move, honestly. So let's talk about these court rulings because they're absolutely delicious. First up, in 2024, Federal Court Justice Richard Mosley dropped a decision that was basically a judicial MIC drop. He ruled that the government's use of the Emergencies Act was unreasonable and violated charter rights. Specifically, freedom of expression, which, you know, is kind of a big deal in a democracy. The government tried to argue that the situation met the threshold for a national emergency. The judge said, and I'm paraphrasing here, "No it didn't, try again." But the government being the government, they appealed. Because of course they did. They weren't about to take that L without a fight. So it went to the Federal Court of Appeal, and guess what happened? The appeal court looked at all the evidence, reviewed the arguments, and said, yeah, the first judge was right. This was unlawful. Two courts, same conclusion. At this point, the federal government's legal strategy is starting to look less like a defense and more like an expensive tantrum. Let's zoom in on the charter violations for a second because this is where things get really uncomfortable for Ottawa. The Canadian Charter of Rights and Freedoms is supposed to be sacred. It's the document that protects our fundamental rights, including freedom of expression. And the courts didn't just say the government made a little mistake. They said the Emergencies Act infringed on charter rights. That's not a slap on the wrist. That's a constitutional body slam. The government froze people's bank accounts without due process. They compelled tow truck companies to work against their will. They essentially told Canadians, if you support this protest, even financially, we can ruin you. And they did it all under the banner of emergency powers that, according to two separate courts, they had no legal right to use. This isn't just about one protest or one moment in time. This is about whether the government can suspend your rights whenever it decides something is inconvenient. And the courts just said no, they can't. Here's the kicker though. The Emergencies Act has a very specific definition of what constitutes a national emergency. We're talking threats to the security of Canada that are so serious and urgent that they can't be dealt with under any other law. Think actual war, invasion, insurrection. The kind of stuff where you'd look around and go, okay yeah, we need emergency powers. The Freedom Convoy, whatever you thought about it, was not that. It was disruptive? Sure. Annoying? Absolutely. A threat to national security? Come on, There were existing laws to deal with blockades and protests. Municipal bylaws, provincial emergency measures, criminal code provisions. The legal toolkit was full. But instead of using those tools, the federal government went nuclear. And Alberta called them out on it. In their intervener arguments, Alberta made it crystal clear, this didn't meet the definition. The federal government couldn't prove it. And now 2 courts have agreed. This whole saga also shines a massive spotlight on federal-provincial relations, which in Canada are about as smooth as a gravel road. The requirement to consult provinces isn't just a suggestion in the Emergencies Act. It's literally written into the legislation. And it makes sense, right? Provinces are the ones managing healthcare, infrastructure, policing in many cases. They know what's happening in their communities. If you're going to declare a national emergency, maybe loop them in. But Ottawa didn't. They made a unilateral decision and expected everyone to fall in line. Alberta didn't fall in line. They pushed back, hard. And this is part of a broader pattern we've seen with this government. Whether it's energy policy, equalization payments, or pandemic measures, there's been this constant tension between what Ottawa wants and what provinces, especially Alberta, are willing to accept. This court decision is a win for Alberta, but it's also a win for federalism itself. It's a reminder that provinces have rights, voices, and legal standing to challenge federal overreach. Now let's talk politics because you know this decision has Ottawa scrambling. For Danielle Smith, this is political gold. She's been a vocal critic of federal overreach since day one, and now she's got a federal court of appeal ruling backing her up. She can point to this and say, see? We told you. We were right. It strengthens her position not just in Alberta but potentially with other provinces that are getting tired of Ottawa's approach. For Trudeau and the federal Liberals, this is a nightmare. They're already dealing with declining poll numbers, inflation concerns, housing crises, and now they've got a court decision calling one of their most controversial moves unlawful. It's not a good look. And with a possible election on the horizon, you can bet the opposition parties are sharpening their knives. This ruling gives the Conservatives and others ammunition to argue that the Liberals can't be trusted with power, that they'll trample rights when it suits them. Politically, this is a wound that's going to keep bleeding. But beyond the political scoreboard, this decision matters for every single Canadian who cares about freedom. And I mean actual freedom, not just the word people throw around at rallies. The courts just reinforced that the government can't suspend your rights on a whim. They can't bypass the Constitution because something is politically inconvenient. They can't ignore their own laws and expect to get away with it. This ruling is a check on power, and in a democracy, those checks are everything. Because here's the thing, today it might be a protest you disagree with. Tomorrow it could be a cause you support. The principle remains the same. If the government can do this once and get away with it, they'll do it again. The courts just made sure that precedent doesn't stand. And Alberta's role in this fight? Absolutely critical. They used every legal tool at their disposal, just like Premier Smith said they would, to push back. That's not just good governance. That's essential governance. So where does this leave us? The Federal Court of Appeal has spoken. The Emergencies Act was unlawful. Charter rights were violated. Alberta was right to push back. And the federal government is left holding the bag on one of the biggest constitutional failures in recent Canadian history. Premier Smith and Minister Amery aren't just celebrating a legal win. They're standing up for a principle that matters to all of us, whether we live in Alberta or anywhere else in this country. The government doesn't get to play fast and loose with our rights. Period. If this story fired you up, do me a favor. Smash that like button, subscribe to Canadian Insights, and hit the bell so you never miss an update. We post multiple videos a day breaking down the political chaos so you're always in the know. Drop a comment below and tell me what you think. Was the Emergencies Act justified, or was this federal overreach at its finest? Let's talk about it. Thanks for watching, and I'll catch you in the next one. Stay informed, stay free, and keep questioning everything.